We ask these things in your name. Amen.
Thank you. Apologies. Member Davis. Senator Bunting. Member Chuck will be a little delayed. He said he'd arrive about 10:30. And we're also expecting Member Malahoo Fort. So I wish to welcome our members to this sitting of the Joint Select Committee. We had a long and very effective one yesterday. We covered 3 presentations, and today we will have presentations from the National Integrity Action and the Jamaica for Justice groups. We are expecting a very fulsome discussion as we had yesterday, and we are going to, on the basis of that, move straight into the presentation, and in the process to welcome the Professor Dr. Trevor Monroe and his team, and to ask him to make his opening remarks and introduce his team.
Thank you very much, Mr. Chairman, members of the Joint Select Committee. Thank you for your welcome. This morning, I have with me, to my immediate left, Ms. Danielle Archer, Attorney at Law, a member of the Board of Directors of National Integrity Action, Mr. Lenworth Burke, the Legal Advisor and Board Secretary to NIA, and Mr. Marlon Moore, who is the Project Officer of NIA. We're very happy to be here, Mr. Chairman, and we welcome the opportunity to make the submission to the Joint Select Committee. Before doing so, we wanted to note in appreciation that this Joint Select Committee is convened in accordance with the Integrity Commission Act within the time frame envisaged in the Act, which requires within 5 years the initial review of the legislation takes place. And I do make this observation because, as you may know, even more so than I, in too many occasions when reviews are required by the statute within a particular time, for one reason or another, it does not happen. In this case, this is not the situation, and we're very happy for that. We also take pleasure in participating in this review because obviously the reason why that clause was put into the legislation is because the Parliament anticipated that in the first few years of the operation of the law, there would be issues that would require review and possibly amendment. And since we, NIA, take pride in the fact that we are very strong advocates of the Single Anti-Corruption Commission and participated at different stages in its development, we're happy to be participating in this first review. We would like to refer initially, as I go through the submission, which I'm sure members have read, but I'll simply refresh and then go to some supplementary points. We refer to Section 3B of the Integrity Commission Act, which the Integrity Commission is required to, and here I quote, enhance public confidence that acts of corruption and impropriety committed by persons exercising public functions will be appropriately investigated and dealt with in a manner that achieves transparency, accountability, and fairness. To achieve this object, specifically in the purposes of the Act, we submit that Section 53.3, the so-called gag clause, should be, excuse me, Chairman, that this clause should be deleted or substantially amended in order to, and I wish to stress this point, to balance transparency and accountability with confidentiality and fairness. We have set out this perspective on a number of occasions, and I refer to two such in the submission. We associate ourselves with the position statement of the Integrity Commission, but of course, we do not accord in all respects, but we are sympathetic to the view in their submission, which you would have been reviewing in your session yesterday. We wish to reinforce our position, drawing on international standards and aspects of law and practice governing anti-corruption agencies in comparable jurisdictions. We acknowledge, and I want to stress this point, research input from and provided by Transparency International, which, as you know, Chairman, has chapters in 100 different countries, including Jamaica, where NIA is the chapter of the Transparency International. It's a leading non-governmental organization combating corruption on a global scale. And we felt that, given the importance of this occasion, we ought to supplement our own research by drawing on their experience in various countries. And to that extent, the research which they did, I would bring to the attention of the committee, covered 8 different countries: Botswana, Canada, Hong Kong, Malaysia, New Zealand, Nigeria, Singapore, the United Kingdom, and of course, Jamaica. In none of these 8 different jurisdictions is there a statutory prohibition or, colloquially, a gag clause of the nature that exists in the Jamaican legislation. I hasten to say, however, that in almost every case, discretion to state whether an investigation is underway or not is guided by criteria which are weighted in favor of non-disclosure. And I repeat that, because of the reputational issues that I know are of great concern to this committee. But the discretion exists. In our case, it does not. And to that extent, the Jamaican statute stands alone and is unique. I go initially to the international standards, the United Nations Convention Against Corruption, of which Jamaica is a signatory. It's the only legally binding universal anti-corruption instrument, and anti-corruption agencies received international recognition under Article 6 of the Convention, and that sets out an institutional framework to implement anti-corruption prevention strategies mandated under Article 5. The technical guide to the Convention highlights the need for both independence and accountability of anti-corruption bodies, citing that there ought to be mechanisms to ensure transparency and accountability of the body or bodies. The 2009 guide also recognizes that transparency processes, including disclosure and reporting, should be cognizant, and here again I stress, cognizant of confidentiality requirements due to the sensitive nature of anti-corruption work that can often put an individual's reputation at risk. Here we see enunciation of the international standard to balance. If I were to characterize our submission and to use one term that would sum up our position, it is the word balance. To balance transparency and confidentiality, not prohibiting an answer yes or no to the question, is the matter being investigated? Similarly, the Jakarta Statement on Principles for Anti-Corruption Bodies in 2012 has an approach that is quite similar. In relation to information disclosure, the Jakarta Principles recommend that anti-corruption agencies engage with the public regularly in order to ensure public confidence in its independence, fairness, and effectiveness. The literature suggests that ACAs, anti-corruption agencies, disclosing information around investigations transparently is often limited to the public interest for various reasons, including the need to build trust in the work of the ACA, and I underline this, to encourage persons with evidence and whistleblowers to come forward to assist an investigation. And may I pause here, Chairman and members, to refer to a news item yesterday purporting to reflect remarks made by Member Chuck, very insightful and useful remarks, where Member Chuck suggested, in fact stated, that the Auditor General makes no statements prior to completion of a report, which is then submitted to the Parliament with good results in terms of review by the Public Accounts Committee and other appropriate bodies. So, in contemplating Member Chuck's remarks, I went to the Auditor General's website and I took a look at the Financial and Administration, the Act governing the Auditor General, and subject to correction by those who know better, particularly Member Robinson, I could find no prohibition, no statutory prohibition in that Act constraining the Auditor General from making any statement. She does not, in the way that was assumed the Integrity Commission wishes to do, but there's no statutory prohibition as far as I'm aware. But beyond that, when I went to the Auditor General's website, the first item on the menu is Audit in Progress. Audit in progress. Prior to reporting to the Parliament. And underneath the heading Audit in Progress, I asked the committee to take note of the following remark on the Auditor General's website. Quotes, "The main aim of listing the audits in progress is to allow citizens / whistleblowers to provide information that may be useful to the audit." It goes on, here I quote again. "If you are interested in leaving an important feedback, follow the link. All information will be treated anonymously." I mentioned this, Chair, in supplementing the remarks of Member Chuck, and I asked myself, the Auditor General is allowed to put on the website audit in progress to facilitate whistleblowers. What compelling reason could there be for the Integrity Commission not to be able to put on its website investigation in progress? But I move on. I go to case studies of the different equivalent agencies to our Integrity Commission. On review of relevant anti-corruption agencies in Canada, the United Kingdom, and New Zealand, in part reveal that there is no gag order on any agency comparable to Jamaica's Integrity Commission, that which exists in our commission. However, I hasten to add, in each case, the relevant regulation or law, while providing a discretion, sets out criteria to guide the use of this discretion, balancing confidentiality requirements with adequate transparency procedures. The New Zealand example is particularly illustrative, and in NIA's view, provides a good model on the basis of which our Integrity Commission Act 53.3 should be repealed and replaced with a clause providing criteria in the law, in regulations or in a schedule, for balancing transparency, accountability, and fairness, stated as one of the objects of the Integrity Commission Act. In New Zealand, the Serious Fraud Office is a lead law enforcement agency equivalent to our Integrity Commission. It is also tasked with anti-corruption prevention. With respect to investigations, the SFO considers several matters. It's obliged to consider several matters. Doesn't have a choice before making a public statement so as to enhance but not compromise the investigation. The factors on the basis of which the SFO decides whether to issue a public statement include, number one, public interest. It's an overriding public interest test. Two, reputational damage. Two have to be balanced. Or harm to individuals or businesses under investigation. Three, level of detail required to ensure high levels of accuracy in reporting. Four, other information which is in the public arena. For example, confirmation of a referral to the SFO by another agency. In that regard, I refer to one of the anomalies which illustrate one of the issues of concern. In May of 2019, the Daily Gleaner reported that the Commissioner of Police disclosed that former Minister Reid was being investigated by the police as well as by FID, and there was a referral to the Integrity Commission. Look at the anomaly. This was 5 months before the charge was laid. The Integrity Commission couldn't say yes or no, because they are prohibited under this clause from confirming or denying whether an investigation is underway. Taking the above into account, the website of the SFO identifies a number of entities that the FSO is investigating. Information on cases is published in categories of open, investigation, prosecution, and close. Please note, in some instances, the identification of the entity is accompanied by a request similar to that on our Auditor General's website as the reasons why disclosure of an investigation, in that case of an audit, is being done. Please, quote unquote, please contact the SFO if you have information that may be relevant to this investigation by emailing, etc. In the interest of completeness, we note that, quote, and this is very important, the SFO will not generally comment on an investigation until the point where charges, if any, are filed. In general, that's a general practice. Why? A statement that the SFO is investigating a person or entity can cause damage which cannot be remedied, even where it is later decided there is insufficient evidence to commence proceedings. End of quotes. So here is a general rule with which we do not quarrel, but it does not constitute a statutory ban. A general rule is subject to exceptions, and the exceptions are qualified by constraints and criteria which are stated. We therefore, with respect, recommend the New Zealand model as the basis for deletion, replacement of Section 53.3 of the Integrity Commission Act, insofar as there is no gag clause with an absolute prohibition against disclosure in relation to the commencement of an investigation. But there are comprehensive criteria on the basis of which the use of the SFO's discretion is facilitated as well as circumscribed. NIA submits that given the basis on selecting Jamaica's integrity commissioners, and let it be noted that the Parliament, in its wisdom, decided against a single commissioner, which often exists in other jurisdictions, for a collegial commission. And it is the collegial commission who shall exercise the discretion that we are confident that the above criteria would normally be factors for publicly commenting on whether an investigation is being undertaken. However, in the interest of building and broadening public trust beyond existing levels, the specification of these criteria, as in the New Zealand and other cases, we regard as appropriate. And we commend this recommendation to members of the committee in furtherance of a goal shared by the Integrity Commission, NIA, and this Joint Select Committee, that of enhancing Jamaica's development through the combat of corruption and the building of integrity, balancing the principle of transparency with that of confidentiality. And if I may, in closing, say that in almost every document related to this issue, that discretion is not at large. It's not left to the anti-corruption agency to do as it would whenever it wants. It's constrained. But there does exist a discretion, in our case, unique in the countries we have looked at, eight other countries, and we could share the research paper done by Transparency International at our request. Of course, it's our position, not theirs. We think that this is an appropriate compromise that could satisfy the twin imperatives of the public need for information, which is our constitutional provision, and the public and the privacy rights of individuals not to have their reputations damaged wantonly. Thank you, Mr. Chairman.
Thank you very much, Professor Monroe. A very broad, detailed, comprehensive, and thought-provoking presentation. And I'm sure that the committee will have responses, questions, and our purpose, of course, is to seek the thoughts and ideas behind the presentations as you make. It's not to make a point as to the accuracy, veracity, or otherwise of the presentation, but rather to inform us as to the thinking behind it, so that when you have left and we meet to review and report, we will have a full sense of what it is that will guide our final outcomes. So I thank you for the presentation, and I now open for comments. I see Member Robinson and then Member Guy.
Thank you, Professor Monroe and team. The question I would posit to you is, Why can't everything that you have outlined be done in a report to Parliament by the Integrity Commission? The Integrity Commission has full latitude to send a report to Parliament to indicate the status of its work. It can say the entities that it has commenced investigations into, and it can do so as frequently as it would want. So the objectives that you have outlined as exist in the New Zealand's SFO, which I fully support, can be accomplished with reports to Parliament right now. And my position is the Integrity Commission should utilize that mechanism to keep the public updated about what it is doing without violating the principles of potentially tarnishing reputations, which are more easily done when you are engaging with the media through a release or interviews. So I would want to know, in the existing provision, where or what do you see that doesn't facilitate what you have outlined?
As I understand it, Member Robinson, a very important suggestion on your part. When I read 36.3, however, of the Integrity Commission Act, it provides as follows. The Commission may at any time submit a report relating to any particular matter. It does not stop there. The section continues, and here I quote, which in the opinion of the Commission requires the specific attention of the Parliament. And the question I would ask, were the intent of the lawmakers to do what is suggested, why would that provision not stop at particular matter, but qualifies the particular matter that may be reported on by the obligation of the Commission to ensure that the matter requires the specific attention of the Parliament? In my opinion, were that deleted, that qualifier deleted, then any matter could be submitted at any time. Beyond that, how would that cure the mischief which is of legitimate concern to members and certainly to NIA, reputational damage of those who are identified or a body which is being named as under investigation?
Well, first, I would have to defer to probably legal minds about the interpretation of what specific means, right? Because the Commission, or special, sorry. I don't consider that a hindrance, personally, and I would need more and better particulars on that to see that as a hindrance. My view on the issue of reputational damage is that in reporting, let's say let me use Petrojam as an example. You can indicate that you're doing investigations into irregularities at an entity. The Integrity Commission doesn't necessarily have to name person A, B, or C until it gets to a point where it believes it has the ability to sustain a prosecution or a charge. But it can right now, it can name the entity within which it is investigating. It can provide a monthly report on, which says we have commenced 10 investigations into these entities. We have 6 of them are advanced, 3 are this, whatever. It has the ability to do that right now. And so the concern that people don't know what the Integrity Commission is doing, and as such you need to remove the guard clause, I don't buy that argument. Because once something comes to the Parliament doesn't, I haven't seen the Parliament exercise any discretion to say we're not going to table this, or we are going to table this. Every time a report comes, it is tabled. And once it's tabled, it becomes public knowledge. So the argument that the clause has to be removed to build public confidence is not one that I buy. And the term special, I haven't seen it thus far be an inhibitor to the Integrity Commission providing reports to the Parliament.
I take your qualification subject to legal minds, which neither you nor I would dare to suggest that we have, but it does seem to me, on the basis of grammar, and I'm not necessarily a specialist in English either, that that clause constitutes a qualifier. Otherwise, it's redundant. But I rest my remarks on that. I would also suggest that the other equivalent agencies are not constrained to report interest, would have to be balanced against issues of reputational damage, that the Commission would have an obligation to do that, and if it doesn't do that, they'll be subject to action if they disobey the law in that specific regard.
I would posit, while I recognize other jurisdictions may not have it, but if you look at and I'd be interested in this, Chairman, and I want to formally ask if we can get this information. From the difference between the amount of announcements of investigation to where either a charge has been laid against the person. I think it's important for the committee to know that, because anecdotally, I think all of us can identify cases where names are put in the public domain, reputations are damaged, nothing comes of it, but the damage can't be repaired. So for me, I would love to know how many of those investigations under the former OCG led to some successful prosecution or the ability to lay charges. And we are grappling with an issue. There are very low levels of trust in public officials, and there are studies that have confirmed that. And I'm clearly in support of transparency as far as it helps the public interest and build public trust. But I have to protect the interests of individuals who in our society have that damage and really very little or no recourse.
Sure, without prolonging this dialogue, I'd say one thing. Perhaps I, more than most others, very sensitive to the issue of reputational damage without appropriate recourse, information, or evidence. However, in this case, I would suggest that one of the reasons why, in the wisdom of the lawmakers, and I believe that I may have been a part of the initial discussions which led to the Single Anti-Corruption Commission, that we provided for a collegial commission as distinct from a single commissioner, as distinct from what obtained with the Office of the Contractor General, is precisely to have an institutional safeguard against a single person exercising this massive discretion. And to that extent, that not only a collegial commission, but one that has to include former High Court judges who would be very sensitive to issues of the kind that you and I are concerned about, which is reputational damage.
Chair. Yes, thank you very much, Chairman. Prof, essentially the gist of your presentation is that you're asking that the gap clause be removed and that there's some discretion applied in terms of what is released by the IC in terms of its investigations, that sort of thing. And you extensively quoted the SFO out of New Zealand. And my understanding is that in all areas when legislation is crafted, it has to be contextual. It can't be absolutes. New Zealand is a fairly large country compared to Jamaica, and I go back to the whole point of reputational damage, which is important, especially in a very small society such as ours. And whereas I see that they have the factors which determine whether they release a certain information about an individual or entity, and those have to be factored, public interest, reputational damage, or so on, all the other rest as you have cited. It still is a cause for concern, though you have indicated in the latter part of the submission that based on who the individuals who are usually members of the commission, it still does not absolve or negate the concerns that we have as it relates to reputational damage, which is very, very important. And as Member Robinson indicated, we start from very far behind in that if you want to take the group of members of parliament, there's a significant lack of trust there. And when you go or when the entity goes and make a statement about a member of parliament or a senior civil servant, public servant, and at the end of the day, that investigation proves futile, proves that there was nothing for that initial. In the society, they are no longer credible, respected. They are almost like pariahs in the society. Now, how do we pull back from something like that?
My plea is that there be balance between potential reputational damage and the public interest. Not that reputational damage is to be subordinated in all cases, but on a case-by-case basis, the commissioners will be obliged to make that balance. And I wouldn't want to, but let me make the observation. If I go on the website now of the Jamaica Constabulary Force, I will see listed, quote unquote, persons of interest. In each of those cases, one would presume that there's reputational damage. But obviously, the JCF has made the judgment that the public interest in having persons come forward either as witnesses or otherwise outweighs the reputational damage invariably to persons who are in lowly positions. So, and perhaps they go too far, naming too many persons of interest, but it does not, by virtue of that naming, and I make myself subject to the learned attorneys who are here, create a presumption of guilt or constitute an allegation of wrongdoing. But it does, I would say, convey reputational damage. I am not suggesting that there is a social criterion being used here, that whereas such people may be named as persons of interest, that the Integrity Commission should adopt the same procedure in respect of persons who they may wish to investigate or they have cause to investigate. What I am saying is that there's very good reason to repose confidence in making that balance in a collegial commission constituted in the way that this one has been, by careful consideration of the Parliament. And I recall very explicitly a distinction and a deliberate decision being made that it should not be a single commissioner. So I share your concerns, member, but in a society and in a country, small society as you say, but one that has tremendous potential to lead the world on issues of governance, as we now do in questions of freedom of the press, rank above the United Kingdom, United States, and 100 and odd countries to rank in the first top 10. We have that potential to rise in terms of integrity, the legitimacy and effectiveness of our anti-corruption institutions. And I think this is one element where our uniqueness is not something that we should be proud of, something we'd have to extraordinarily justify. And I don't think that what we have said so far justifies retaining that absolute prohibition, which would say to the Integrity Commission, if you are investigating a municipal corporation, you can't state that to the public. You ask a question, you can't say yes or no. You have to go to the Parliament, as Member Robinson suggests, on the grounds that it will be a matter of specific interest. I think that this is an excessive curb.
Thank you, Chairman. First of all, I want to associate myself with what Member Robinson said, and to emphasize to the public who, I get the impression that many are following these proceedings, that the government of which I'm a part, we are determined to wipe out, deter corruption. And that is why the Integrity Commission that asks, I don't think they've asked for anything that has not been provided in terms of resources. So their budget is over $1 billion now. And I can say, in relation to the adjustment to be made to this Integrity Commission Act, I will do anything that can improve the deterring, exposing, and punishment of corruption. So we're on all fours in relation to this act itself. That is why it is before us. And as you say, the question is one of balancing between reputational damage and conducting investigations. I start out by saying I've seen far too many instances where allegations of damage, not only reputation, but create conditions that cause Jamaica to lose multi-billion-dollar investments. And the best one is one where, and I think it's since it was in the public sphere, Moon Palace wanted to buy rooms. There was a valuation for 14 million, but the sale price was 8 million. Agreed sale price was 8 million US. No one did the investigation to note that Moon Palace was really just interested in the land and not all the structure in it, because they were going to tear down everything and put up a multi-story, a multi-billion-dollar investment. Everything was the allegation, valuation 14 million, sale price 8 million, without looking behind what is it Moon Palace was going to do. And you are aware, it was all in the public sphere, imputation, speculation of corruption. And at the end of the day, Moon Palace withdrew a multi-billion-dollar investment, including, to the best of my recollection, a spending of 500 million US to improve the ambience around Moon Palace and around that end. So, allegations of corruptions and, exposing investigation like that without giving the full details and imputing corruption can be damaging to the investment climate in Jamaica. And I can tell you, I know many persons where, even though, nothing has been found, all the allegations were ill-founded, because they have been exposed in the public sphere, they suffer reputational damage. I can tell you, Professor Monroe, that there are many police officers who are very wary about the weekly press conferences coming out of Indicom about policemen being investigated. And I used to say to the then commissioner of Indicom, why don't you let people know that some of these allegations are ill-founded, because 19 out of 20 allegations were found to either be ill-founded or nothing was happened. 1 in 20 of the investigations of these allegations prove that some penalty should be imposed, such as disciplinary action. And I can tell you, I have seen it in the last 3-4 years, where I'm aware that the Integrity Commission is investigating matters, because I know ministers have been interviewed, where people did not get a contract, somebody else get the contract, but because somebody else get the contract, they impute that there must be corruption why they didn't get it, and they appeal. Unfortunately, I suspect, as I said to the commissioners, so to the executive director yesterday, their investigation found nothing, because nothing has been reported of substance to say that corruption was found. So the real challenge, Professor Monroe, NIA, how do you make that sharp distinction between allegations which investigation can find to be well-founded, or where investigations are found to be ill-founded? And I dare say that in our Jamaican context, more than 50% of the allegations are ill-founded. And if those investigations should be supported by the Integrity Commission saying, yes, we are investigating, which gives substance, the damage to persons, even if they're not named. Because if it is the Ministry of Justice, they're going to say the minister must know about it. That is what it will happen. So, or if it is Petrojam, they're going to say the executive director must know about it. Or if it is the court, they're going to say the Chief Justice must know about it. And at the end of the day, it may well be founded. So what we're really asking, and this is where I agree in substance with what you have presented, let there be a report, yes, on the state of what is happening, but that report must come to Parliament, so that the commissioners must properly prepare that they are investigating this. They have reached a stage where they're asking for more parties who know about it to provide information, but not by way of a press release. Send it to Parliament, and I will agree with you that Section 36(3) should be amended. The Commissioner may at any time submit a report relating to any particular matter. Sorry? No. I would be willing to have a look at this and ask you the question. Suppose we say the Commission may at any time submit a report relating to any particular matter. Full stop, right? That's something that we should really consider. The reason I'm saying so is that, yes, as you quite rightly say, there are 5 outstanding commissioners who, before any matter is sent to Parliament, I would hope they have given it due consideration before they send it to Parliament. And why I'm insisting that you can report to Parliament on a weekly basis, okay, of what is happening, where matters are being investigated, but it must come to Parliament. And the reason I'm saying so, Professor Monroe, is that the Integrity Commission is a commission of Parliament. And being a commission of Parliament, report to Parliament. I can't see why it should be reporting to the Media Association and the Press Association of Jamaica, because they're the ones who want a headline. And I know everybody's looking for a scoop. Right? And all I'm really saying, I believe the Integrity Commission must be open and transparent, but do so through the avenue of Parliament. Would that be, and once it's reported to Parliament, people can comment on it?
I think that would be a step in the right direction, Member Chuck.
Sorry, just prior to that, I just want to, as a matter of housekeeping, and sorry to interject at this point, but part of what we try to do here is to be less prescriptive in these discussions and to look behind what you're saying to understand better why you have submitted what you have submitted for us to consider as a committee afterwards. So I'm just trying to guide the discussions to ensure that we are not being prescriptive at this time. Thank you. Go ahead.
I was about to say that I think that suggestion would be a step in the right direction, because it would add implicitly a constraint for the commissioners to consider, an additional constraint, namely, could their statement to Parliament that a particular matter is being investigated be sufficiently grounded as to not attract a charge of being whimsical or arbitrary. But I do think as well that there would remain serious concerns with fairness. Let me perhaps use a sensitive example. At the present time, the Commission has put in the public sphere that they are not in a position to certify the Prime Minister's statutory declaration, not in a position to certify. I get calls from all kinds of persons yesterday as to why can't the Commission say why not? The answer is they're not allowed to. No, the question is, this, it seems to me, is both unfair to the Prime Minister as well as to any person put in that situation. In this case, the law does allow a level of transparency, which I fully agree, namely that the Leader of the Opposition statutory declaration summary and that of the Prime Minister should be gazetted, and by virtue of being gazetted, available to the public. Now, when it is not gazetted and questions are raised, that clause, I believe, and subject to better legal view, prohibits them from saying, look, it's a clerical issue, it's a matter of time, it is out there in the domain, leading to the kind of unfounded and ungrounded speculations, but which cannot be corrected by the very commission that is obligated to say, why is it that the Gazette has not carried the PM's summary of statutory declaration in the way that it has carried the Leader of the Opposition. So I'm saying that there needs to be more flexibility beyond what you are agreeing with me could be done, which is to delete that section of the Act which limits it to specific matters being reported to Parliament.
I think that, we have very extensive discussions as we seek to get behind what the thinking that inform your submission is, Professor Monroe. And I think that we sometimes end up with examples which offer an opportunity for you to move into areas that are even not immediately under consideration. But the point is taken that the Commission has a responsibility not to move in a sort of half-baked manner, but rather in a fulsome manner based on the level of investigation it has done and the satisfaction that it has as to the veracity of the data and so on that it has received. And it is quite correct that it should seek not to divulge information which is not yet ready for the public. And therefore, I think that this whole discussion is part of that wider protection, not just of the individuals who may be hurt, but the Commission itself in terms of its own integrity, in terms of its output. So I think that's a consideration to guide the further discussions this morning. Member Malahufort.
Thank you, Chairman. Morning, Professor, to your team. Good to see you. Good to see you, Mr. Archer and Mr. Burke.
Please don't leave out Mr. Moore.
Greetings to the entire team, NIA, and thank you for your submission, always well-reasoned. Just seeking to drill down a little bit. So the argument, as I understand it, is that the presence and continued presence of the provision which restricts disclosure until a certain event has happened decreases the capacity of the Integrity Commission to do its work. And in particular, I see you have linked it to the object, one of the principal objects of enhancing public confidence that acts of corruption and impropriety committed by persons exercising public functions will be properly investigated and dealt with in a manner which achieves transparency, accountability, and fairness. That is set out at section 3D, and that's the general argument. Let's just look at what the Commission is empowered to do to achieve the objects that are set out at 3. I mean, the objects include further encourage and promote propriety and integrity among persons exercising public functions in Jamaica, promote and strengthen measures for the prevention, detection, investigation, and prosecution of acts of corruption, ensure that government contracts are awarded, varied, renewed, or terminated impartially, on merit, and in a financially prudent manner. And the object you have highlighted to ground your reason for the request to repeal that subclause. But let us look at the specific functions of the Commission set out at Section 6.1 of the Act. And in particular, the functions set out at Section 6.1D and G, H, and O. So, subject to the provisions of the Act, the functions of the Commission shall be to examine the practices and procedures of public bodies and make recommendations in relation to the revision of those practices and procedures, which, in the opinion of the Commission, may reduce the likelihood or the occurrence of acts of corruption. I don't know, Chairman, whether any information has been presented to the committee so far on the examination of practices and procedures in public body. I don't know if the NIA has done any work around this particular issue to see what are the practices and the procedures of the public bodies that need to be revised, those which right now provide an avenue for occurrence of corruption and where changes may be done to reduce the likelihood. And then another, it's about preparing codes of conduct and other advisory material relating to corruption and to guide public bodies in respect of matters within the purview of the Act. When we skip over, we see determine the extent of financial loss and such other losses to public bodies, private individuals, and organizations, including losses sustained by the private sector as a result of acts of corruption. And the big one, adopt and strengthen mechanisms for educating the public in matters relating to corruption. All right, so those are heavy matters. I mean, serious powers. They're deep and broad. The provision that you quoted at section 36.3 3. Now, Section 36 speaks to reports. The Commission, first of all, may at any time be required by either House of Parliament to investigate matters relating to an act of corruption and table a report thereon. The Commission shall not later than 3 months after the end of each financial year or within such longer period as a Parliament may approve, submit to Parliament an annual report relating generally to the execution of the functions of the Commission during the preceding financial year, which shall contain the information that is set out in the schedule. And then to 3, which you have taken issue with, the Commission may at any time submit a report relating to any particular matter which, in the opinion of the Commission, requires the special attention of Parliament. And you're saying the inclusion of the ultimate clause, a matter requiring the special attention of Parliament, restricts what the Commission would, in its opinion, believe appropriate to refer to the Parliament. But let us look at a little bit of the definitions and see how we put everything together. So, a public body means a ministry, a department, or agency of government. Naturally, the Parliament would have a special interest in such. A municipality or a municipal corporation, because we also have a minister who sits with portfolio responsibility for local government. A statutory body or authority, and statutory bodies are required to report annually to the Parliament, so naturally the Parliament would have a special interest. Then an entity, the governing body of which is appointed by a minister, that too is a matter for Parliament, for the Parliament's special interest. A company registered under the Companies Act, being a company in which the government or an agency of the government holds at least 50% of the voting shares of the company. That, by definition, makes it a public company, which the Parliament would have a special interest in. And then when we look on the definition of public functions, it means any activity performed a single time or continually, whether or not payment is received therefore, which is carried out by a public official or a person for or on behalf of or under the direction of a public body. And the public official means a person holding an executive, an administrative, or a judicial office, or a parliamentarian, whether appointed or elected, whether permanent or temporary, whether paid or unpaid, and any other person who's employed to a public body, and also a member of the security forces. And the security forces means the JCF, the JDF, and the rural police. And I just wonder, given the remit, what could the Commission be investigating that Parliament would not have a special interest in, given what Parliament is supposed to do? I don't know, maybe you have a thought on that.
As I understand it, you're saying that the clause therefore has no limiting capacity. It's redundant because the Parliament has an interest in everything.
So my little training tells me that a clause has to be read and understood in its wider context. Mm-hmm. And I think it's important to understand what the Act is empowering or what it is enabling. So it establishes a commission with a specific functions, and the commission is built out. I'm just wondering, in that context, I didn't immediately appreciate the perspective from which you came to say that that provision would limit. The only limitation I would see is what the commission opines on, because it is in the opinion of the commission. So if the commission takes a very narrow view and opines very narrowly and say that this is not a matter that the Parliament would have a special interest in, therefore it would not submit the report. But when you look overall, I could see very little that the Parliament would not have a special interest in.
Hence, the clause ending at any matter would suffice, because the Parliament, as you know better than I do, its function is to make laws of peace, order, and good government. And
That's right.
Therefore has an interest in everything, and to that extent a special interest in nothing.
But I really...
So why would we include that in the provision to the extent that it is not limiting? Because you're...
Or is it the opinion of the Commission that is the limiting word? Or is it the opinion of the Commission and what the Commission would opine on? Because the Commission may at any time submit a matter relating to any particular, a report relating to any particular matter which, in the opinion of the Commission, requires the special attention of the Parliament. But let's go back, let's go back. So generally, the Commission is submitting reports and annual reports. And then, no, the Parliament itself may ask the Commission to investigate and submit a report. And then it may do that. Maybe I'm a little slow, but I'm really not appreciating the limitation from the Parliament's perspective. Because it would be, the proper question is, how is the Commission opining? How is it limiting itself to say, this is not a matter that I should bring to the attention of Parliament?
Member, I appreciate the issue that you're raising, but I do empathize more with Minister Chuck's suggestion, and in agreement with mine, that the removal of that particular clause in that particular statement would make it clearer, not just to the Commission, but to everybody else, that they can submit any matter to the Parliament. But I don't, I know, we can agree to disagree.
I don't think that the clause, the provision as worded, limits the Commission. Any limitation would be the Commission's own limitation as worded. Because in effect, any matter of corruption, any matter within the purview of the Act can be submitted to the Parliament. So it's really giving the Commission a little space to pause and say, you can determine whether this is a matter that you wish to escalate up to be brought here. And I think it's appropriate so that not every single matter is required to come, even though there should be an interest in matters under investigation. All right? Let's...
I understand what you're saying, Member, but we may agree to disagree agreeably on
absolutely.
that.
Absolutely.
But you did raise
that's the beauty of an exchange. But just take a look at it. Again, you may have the assistance of learned counsel.
I crave your assistance all the time, but you did raise a number of other issues.
But look again. So
you did raise a number of other issues which I want to just make a very brief comment on. A very brief comment on the other issues that you raised. One of them is whether NIA is aware of or has done any research in respect of public bodies and how to limit the extent to which these may be facilitative of corruption or unfair practices. And the short answer to that is that we did quite a bit of work and gave significant and sustained support and commend the Parliament for the ultimate passage of the regulations in December of 2021 governing the Public Bodies Management Accountability Act, which has gone a substantial way to reducing the extent to which public bodies have traditionally across administrations been peopled at the level of the board by persons without necessary competence, skill, or experience, but by virtue, if not primarily, substantially on the basis of their support of a political party. And that has been an important step forward, and we are now looking forward to the implementation of the changes in board membership in accordance with that very significant step. which legitimately and understandably provoked, in the words of the Prime Minister himself, significant dissent, as some did not agree with the changes that are ultimately embodied in the Act. Secondly, you raise the issue of code of conduct. Very, very important and a matter of great concern to national integrity action. And we note in that regard that 2 of the 3 branches of governance now have codes of conduct, namely the judiciary and the executive. The missing link is the parliament.
I can tell you that there is one that is in draft now that is being worked on.
Looking forward to that, because
Yes.
that was promised from 2009
Yes.
in respect.
Far advanced. The work is far advanced.
Thank you. That's very, very reassuring, member.
But just to go back and the work on the stat bodies and the appointment of directors is a bit of work that I myself, in my former role as Attorney General, was intimately involved in. And I think all the input made a huge difference to the output. But I just wanted to go back to the argument around the presence of the clause which restricts disclosure until the happening of a certain event, in that case, the tabling of a report. So you are associating yourself with the position taken by the Integrity Commission, and succinctly, the Integrity Commission is saying that the presence of the clause makes it comatose. That was the word used by the executive director. And again, I've been thinking, with all of what the law empowers the Commission to do, in a way that is wider than other pieces of legislation, I still cannot understand why what I read as umbrage being taken to a provision which says, just wait until you table it. Because in addition to its functions that are set out at section 6.1, the Commission shall be responsible for developing the strategies, direction of the Commission, and in the exercise of its powers and performance of its functions under the Act, it shall not be subject to the direction or control of any other person or authority other than the court by way of judicial review. The only other provision we have in law like that, is in the Constitution in relation to the DPP's office, in other words. It shall act independently, impartially, fairly, and in the public interest, and shall have the power to do all such things as it considers necessary or expedient for the purpose of carrying out its functions. And then when we look at 53 itself, 53 speaks to restrictions on disclosure generally. It begins with disclosure of information that the Cabinet Secretary gives a notice in relation to. And in all jurisdiction, a special carve-out is made for non-disclosure of matters that involve the deliberation of the proceedings of Cabinet, all right, to enable free discussion. Then it speaks to prejudicing the relations of Jamaica with the government of any other country or with international organization, and prejudice the detection of offense and other matters relating to the defense of Jamaica. And then this clause, which, I've really been trying to understand why such a focus on it. And having listened to the presentation of the Commission, I still am left without an answer as to why it has interpreted and restricted itself in the way it has, to give the public the impression that this clause prevents it from doing nothing. And unless and until it's able to call a press conference and say what is happening, then it really isn't able to command the stature that it desires to command. I really am not, I haven't gotten it, and I'm open to persuasion, even if it is in a minority way. But I honestly have not gotten it. So the provision says, until the tabling in Parliament, why is there such umbrage to waiting until a report is tabled in Parliament? Until the happening of that event, all matters under investigation or any other person by the Director of Investigation or any other person involved in such investigation shall be kept confidential, and no report or public statement shall be made by the Commission or any other person in relation to the initiation or conduct of an investigation. It's only until the tabling. And then it says, nothing in that provision shall prejudice the taking of any administrative action or the initiation and conduct of any proceedings. So you have to read 53.3 and 53.4 together. It's very wide. All it simply says is that before you go there, table it here. There is no fettering thereafter. And when you look on the functions that are set out and the powers, they are so wide that they would enable the Commission creatively to get the information that it requires. So in a society like this, I know the lens are focused on parliamentarians. And the parliamentarians occupy a very special place. But we are a small subset of those who are liable under the law. The confidence in public offices, probably already ruined. But what are we seeking to do? Professor, I really am at a loss as to why the Commission and good bodies like yours view that clause, which took into account the need for transparency, but was trying to strike a balance to say that people who, we've had too many examples of a huge hue and cry, and then it falls to nothing. Maybe it is that in a society like ours, where it's difficult to get evidence to meet the legal standard of proof beyond reasonable doubt, we should really consider what other action can be taken just below that threshold to help hold people accountable. And remember now, even with that clause, the Commission is still permitted to take administrative action. It is still permitted to conduct, initiate and conduct other proceedings.
Yeah.
I am so disappointed, maybe it's my denseness, that all of the strong arguments presented are yet to convince me. Maybe convince is too strong a word. Because I don't think any of us here is less committed in the goals that we're seeking to achieve, having placed ourselves in public service in an unthankful way.
May I be brief, Chairman, if I can?
And I just urge committee to appreciate that we do have another presentation to be made, and we have to be out of here by 1 o'clock so as to facilitate Parliament this afternoon. So I know that this is a very hot button matter, subject, and certainly NIA has come with a lot of very strong, provocative, and interesting and exciting presentation and ideas. But we do have to truncate after this response so as to allow for Jamaica for Justice to make their presentation. Thank you.
I would propose and ask the Auditor General, before she tables a report to the Parliament, exercises the discretion to put on her website the first item on the menu, Audit in Progress. The website explains that the main aim of listing the audits in progress is to allow citizens, whistleblowers, to provide information that may be useful to the auditor. End of quotes. Our submission is, given what you describe as the latitude available to the Integrity Commission, that the Integrity Commission have a similar capacity to place on its website, using the criteria of balancing the public interest, the need for citizens to get involved either in exonerating or confirming an allegation. They have that facility in the proposal we are making to balance that discretion.
Would you say the comparison is between two different
I make the comparison.
Very different comparison.
I make the comparison arising from a very insightful observation.
Very different.
The very insightful observation made by Minister Chuck yesterday.
May you just pause? Through you, Chairman, I will just yield briefly
let me
to
tell
Member
you
Robinson.
Let me explain the fundamental difference between how the Auditor General works and the Integrity Commission. The Auditor General routinely audits ministries, agencies, and departments. She may commence a special audit if she has information that points to impropriety. But the nature of that department is that she does audits on a regular basis. So the fact that she places on her website the names there's no prejudice there because it's her routine function. When she goes in to do a special audit based on information she has, then that's a different matter. So I don't think the two are at addendum at all.
And the reason why I raised it is because I had great empathy with Member Chuck's remarks yesterday as to how come the Auditor General makes no report to the public or no observation to the public prior to a performance report or special report or the annual report. And I was simply saying that, in fact, citizens have the ability to engage with information that they may have. In this case, as we speak, the audit in progress on the website has to do with the Jamaica Fire Brigade. And that allows citizens who have negative or positive experiences to come forward. Now, I'm fully with you that it's not on all fours, but in the context of the observation that the Commission has more latitude than is being purported, either by the Commission or by others, this would be one area of latitude that they should have a discretion. And I come back to the point, and those who were in the Parliament at that time can recall, the very specific reason why it is a collegial commission with High Court judicial experience is exactly to ensure that no individual, however enthusiastic, however well-intentioned, would have this singular authority to determine whether and how an investigation underway would be released. And I believe that we would all agree, certainly I think on all sides, that the collegial composition of this Integrity Commission, which is somewhat special, many of the serious fraud office in other countries is a single person, we said, no, we want a collegial commission. And I've never heard, and open to pause, Chairman, if there's any member of this Joint Select Committee who has limited confidence in the composition, collegial composition as it now stands. My sense is that everybody has that confidence. We certainly have it, but feel that to go the extra mile, the amendment should include criteria to constrain that collegial commission from issuing a statement, confirming an investigation, to allay perhaps justifiably concerns that this discretion may be exercised in a wanton way. And so while we associate ourselves with the position of the Integrity Commission, our perspective is not identical. We believe that there's room for compromise, there's room for an amendment which could meet both the need to guard against reputational damage as well as the necessity to facilitate the public's right to information as well as transparency. Thank you very much, Chairman.
Thank you very much. I just wanted to join you in the broad comment with regards to the Integrity Commissioners and to remove any doubt or any sense of emotion anywhere that this Joint Select Committee or indeed the Parliament or indeed this government or anyone has anything but full confidence in the commissioners. I wanted that point to be very clear, that this is not a meeting where their confidence is being brought into question at any level whatsoever. I think we want to conclude, but I think two members wish to make very brief, very brief comments.
I simply wanted to ask a question, and had been trying to do so. Because I'm short, you didn't see that I was indicating. But I simply wanted to find out, with the New Zealand model, which Professor is advocating, whether it was actually in the legislation, these guidelines which you specified, or in regulations. You didn't make it clear in your presentation how it was done, and it would have been helpful if you had shared a clause so that when we come to deliberate on a matter, we will have some kind of guidance in that particular area.
I commit to following up in that regard, Member, to provide the exact phrasing and the status, whether it's in guidelines or in the regulations actually governing the Act, within the Act itself.
Thank you.
Thank you, Chairman. My last comment in just thanking the team is to say that it's somewhat unfortunate that the impression has been given to the public that unless the committee accepts a recommendation that the clause is to be repealed, somehow the Parliament is not committed to transparency and the fight against corruption and would be preventing the Integrity Commission from accomplishing the objects that are set out. But I'm asking everyone to just spend a little time and read the provision that has been focused on at 53.3. Read the entire section 53. And also read section 3, 4, 5, and 6 of the law. Because when you see what is set out at section 6 in particular, the functions of the Commission and the powers, the exercise of the functions through its powers, I would like to be presented with a different argument to say how, given the very broad provisions, the Commission is being prevented from achieving its goal simply by requiring that it awaits a tabling in the Parliament before it goes to the press on matters under investigation.
So thank you very much.
Chairman, I'm so sorry you're not seeing me in the back here. I just have a short question and then if I could be permitted. Professor Monroe, in relation to 36.3, the section you read on the submission of a report, which in the opinion of the Commission requires the special attention of Parliament, in your view, would the removal of the word special from that clause provide the kind of latitude that would allow for the transparency that you seek through the tabling of a report?
It would go somewhere, member, but I thought member Chuck's suggestion that the sentence end at matter would be even more comprehensive.
Okay, so once that is done, then it wouldn't be fair to say that there's a provision in the law that could be considered a gag clause.
My own sense is that to satisfy issues regarding reputational damage, it would be best to include in the law criteria on the basis of which the commissioners ought to make the judgment to expose to the Parliament or to the public an investigation. That would be an appropriate constraint, given the concerns which are legitimate in our society based on past experience and the small size of the country. So I would put in the additional issue of a set of criteria, either in the regulations or in guidelines, to govern the Commissioner's exercise of discretion.
And would you accompany that recommendation for the inclusion of that kind of criteria with some sort of remedial clause that would allow for an injured public official to have a remedy in such cases where it turned out that that discretion exercised by the commissioners did not bring to bear prosecution or did not end up in a situation where that public official was found guilty?
I would want to be guided by legal opinion regarding whether that facility doesn't exist automatically. For example, persons in the Jamaica Constabulary Force's website, when you name a person of interest, as there are many there now as you speak, those individuals who can claim a reputational damage by virtue of being named a person of interest and subsequently no prosecution, do they have a right under whatever legislation or common law to then seek damages? I do not know. It's something worthy of investigation.
Okay. Thank you, sir. Chair, thank you.
Thank you again, and just to reiterate that this has been a most satisfying discussion, I think, overall. We have explored a number of areas, and I believe that the committee has learned a lot more about what's behind your thinking, and we will be guided when we make our final deliberations and report to Parliament. Thank you very much for your very, very, what I would call appropriate and adequate submission.
Thank you very much for your patience, Chairman, and we're appreciative of the turnout of members. Some spoke eloquently with the expressions on their face, even though they didn't articulate. And we really do appreciate and understand the careful deliberation that this committee is giving to this very important matter. So thank you for having us, and I hope you don't mind if we stay on to hear the submission of our colleagues from Jamaicans for Justice, or are we expected to leave at this point?
In the normal run of things, we don't have this, but we wouldn't object at all, providing that it is quite understood that your presence will be a silent one. The Jamaica for Justice team, they're coming down here. Well, you may have to vacate that particular location, of course.
I think generally, Chair, we may have to vacate. Full stop.
Thank you very much, Jamaica for Justice, for members. Members, we do have the Jamaica for Justice before us, and Ms. Mikhail Jackson, the Executive Director. I will offer her the floor so that she makes her opening statements and introduce her team.
Good morning to the honorable members. We are certainly happy to be here, and good morning to those who are listening online. My name is Mikhail Jackson, Executive Director of Jamaicans for Justice. Before I start, I just want to say thank you to the Joint Select Committee for allowing us to make a presentation on the Integrity Commission Act. And just by way of acknowledgement of the team that I have here with me, I will allow them to say their own names. Yes?
Good morning. My name is Jade Williams. I'm the Policy and Advocacy Specialist at Jamaicans for Justice.
Good morning. My name is Karen Brown, Communications Officer at Jamaicans for Justice.
All right. So thank you again to the committee for allowing us to make the presentation. We are going to be focusing on some particular and specific points, some of which you have been hearing. And for fear of repetition, I think it is still best for us to indicate where JFJ stands on some of these provisions. Now, the question has always been asked, why is Jamaicans for Justice speaking to this particular legislation, given the mandate of the organization? JFJ has always been involved in legislation that speaks to and enhances good governance. And there are some points of reference that we have here for specific ministries to consider as we speak. But when we look at corruption and the perception of it within the country, we recognize that high levels of perception of corruption undermines trust in the public institutions. And I think we can all agree that that is not something that we want to continue. Because when we have agencies, ministries, public officials that the public does not have that trust in, then we recognize that those agencies are not in a position to fulsomely carry on their duties. Now, there are some things that I want to point out. The provisions that some of my colleagues spoke to earlier in terms of public interest, it speaks to a very utilitarian view in terms of weighing matters of reputation versus what the public will deem necessary. And I want to respond, before I get into the specific points, that silence in and of itself and inability to speak in and of itself can undermine public trust, though the well-intention of the government and the parliamentarians are very clear. They're well-intended objectives. We want to maintain and mitigate against reputational damage. But I re-emphasize the point that silence in and of itself can undermine the public trust in the public officials who are expected to serve. Now, on the matter of the independence of the Integrity Commission, we do agree, and I want to congratulate the Parliament on the steps that it has taken to safeguard the independence of the Integrity Commission. Based on our reading and looking at comparisons across the globe, and we look at integrity commissions and how these anti-corruption agencies are structured, I want to point out, and as Parliament perhaps is very aware, that you will have some investigative powers, perhaps you won't. Jamaica is one of those unique countries where the powers of the investigative powers, rather, also extends to prosecutorial powers. And again, we must applaud Parliament for putting those measures in place. I heard Professor Monroe speaking to the collegial structure of the Integrity Commission, moving from that ombudsman approach that we have seen within the parliamentary systems. And again, this is something that we must applaud Parliament for doing over the years. I see Member Malahou Fort, and something that I hope her ministry will consider and something I know that Parliament has considered with other bodies, is whether or not our first recommendation could perhaps be considered around the Integrity Commission, as independent as it may be, as a Commission of Parliament, as a best practice, whether or not, given its functions and its intention, whether or not it should be, what's the word I'm looking for, upgraded, for lack of a better terminology, to a constitutional body. That is something I'm hoping that Parliament would seriously consider as the Ministry of Legal and Constitutional Affairs lays out its legislative agenda. I'm not sure where the government stands on it, but we are putting our recommendation on record that the Integrity Commission should join with the recommendation of the Electoral Commission of Jamaica and the anticipated National Human Rights Institution to becoming constitutional bodies. The reason for us putting forward this particular recommendation, I did outline at the beginning that the Integrity Commission in its current structure, and I heard the Minister outlining the structures, its independence, the fact that, I don't want to misquote the particular language in law, but the fact that it is not subjected to any other powers per se. But the reality is that the Integrity Commission is governed by ordinary law, if you will. And with that comes the possibility, and I'm not making any absolute statements against any particular member or any government, I want to be very clear. But the fact of the matter is, when you have a body such as this that reports to Parliament, and there are certain provisions within the law that can be changed, may very well stand the possibility of undermining some operational provisions that would safeguard its independence. So I just want to put forward that the recommendation of JFJ is for the Commission, the Parliament, through the Ministry at the appropriate time to consider whether or not the Integrity Commission should become a constitutional body. There is a point that I want to raise, and I will seek the guidance of the parliamentarians here regarding the prosecutorial power of the Integrity Commission. Now, we note that the Integrity Commission is not subject to any other power, with the exception of the Director of Public Prosecution, given that the DPP is embedded in the Constitution. I think Section 94, I stand corrected with that particular reference. My concern is that when we look at the history of prosecution of corruption over the years, there is not high levels of that. It suggests that there's a paucity. It infrequently happens. Now, the Integrity Commission, in our estimation, was established into a single body with the areas of specialization with dealing and handling with matters of corruption. Our reading of the Integrity Commission Act suggests, and I stand corrected again, that if there is a difference of opinion between the Director of Corruption Prosecution, the DCP, within the Integrity Commission, then it is the DPP's opinion that shall prevail. I am not certain whether or not, if it is that Integrity Commission does not become a constitutional body, this can possibly cause hiccups when time comes for cases to be prosecuted if there is a difference of opinion. We sought guidance to other jurisdictions, and the only one that we saw that was comparable was Uganda. And Uganda's model is similar to ours, with the exception that both the Integrity Commission, or the anti-corruption agency there, and its DPP is embedded in the Constitution. And again, we just wanted perhaps clarification from the Joint Select Committee whether or not there is the possibility of considering, if there is a difference of opinion with a case being prosecuted, whether the DCP within the Integrity Commission's own opinion shall prevail, given that the Integrity Commission has the area of specialization compared to the DPP's office. And this is something that I'm hoping the Joint Select Committee can advise on, whether or not that recommendation is possible, given one body is a Commission of Parliament and the other is a constitutional body. So again, we stand open to any possible correction in that regard. I was speaking off the top of my head, given the slides weren't moving, but let me just bring the point back. The other area that I want to make reference to within the context of the ability of the Integrity Commission to act in an independent manner that will fulsomely recognize the powers that the Parliament had intended is around increasing the power of the investigative officer. Okay, all right, thank you. All right, so we are seeing. Now, in looking at the powers of the investigative officer, again, JFJ applauds the Parliament for the current provisions in law where the Integrity Commission is concerned. But we are asking the Joint Select Committee to consider, similarly to what exists in the Turks and Caicos, and I make reference to Uganda and other similar anti-corruption agencies that do have investigative powers, for the Integrity Commission, through its investigative officer, to be given the power of arrest. We read the Office of the Contractor General's legislation before, and if I'm not mistaken, there were provisions within it that spoke to the office then being able to seize and retain anything for which a search has been authorized. And we're asking for a similar provision to be extended within the Integrity Commissions Act. So to clarify what we're asking for here, we're asking for the power of the investigative officer to be increased or improved to include the power of arrest, similar to what a constable has, as well as the power of a justice of the peace to authorize entry and search of premises, etc. And the reality is, while there are provisions within the Integrity Commission for vertical integration, when you look at the consulting bodies, JCF is one, JDF I believe as well, we believe that in some instances, when we see the Integrity Commission really pursuing the cases of corruption, as Member Robinson called for yesterday, there is a possibility for immediate action to be had, and the powers of arrest, in our estimation, and the powers of a justice of the peace may be relevant. So we're asking for that to be considered. My colleague, Jade Williams, will be speaking to the other recommendation around the gag and confidentiality clauses. But before she goes into that, I want to share some survey findings that were carried out by one of our partner agencies, Jamaica Accountability Meter Portal, JAMP, and it was conducted by Trend Media and Silverstone Consulting. And this survey was conducted among 1,609 respondents. And let me share quickly what the survey findings indicated. Good to note that 86% of those who were surveyed do believe that we can reduce Jamaica's corruption problem, which sends a strong signal that the public is with the Jamaican government, is with public officials, and I believe civil society will also play a critical role. So 86% believe that we can reduce the corruption problem. 65% of the respondents, 1,609 respondents here, they heard of the Integrity Commission before. Now, there's a particular question of note that I want to point out, that findings. The question asked within the survey, did you know that the law prevents the Integrity Commission from advising the public when they are investigating any government agency or public official for allegations of corruption? And 40% said yes, and just about 60% said no. Did you know that the law prevents the Integrity Commission from advising the public when they are investigating any government agency or public official for allegations of corruption? And 40% said yes, and 60% said no. The follow-up questions to that, and there are two in the interest of time. Do you think the Integrity Commission should be able to advise the public when investigating corruption and can identify persons of interest in the same way the police can? Just about 66% said yes, and the remaining said no. And I want you to take note of that 60% believing that the Integrity Commission should be able to advise the public when investigating corruption and identifying a person of interest in the same way a police can. The slight difference, however, when we filter and we ask the 40% who were previously aware of the limitation of the so-called gag clause, their response to the same question was 49%, just about 50% saying yes, and 40% saying no. So I think there may be a little bit of a difference when you look at the awareness of what the gag clause is intended to do or not to do, or the perception thereof. And that is something I want the Joint Select Committee to mull over a little bit as Ms. Williams continues with the next points that we have on the slide.
So our next point is in relation to the gag clause that Mikhail just mentioned. And we are in support of statements that other presentations would have made that the section should be either amended or repealed. And we're of this opinion because we see where the inability of the Commission to be able to make announcements about their investigations may hinder the ability of persons with information that can assist the investigation from coming forward. And we also think that it would allow for the Commission to have a greater public confidence in the work that they are doing by removing this section. So we made reference as well to the Serious Fraud Office provisions that Professor Monroe would have mentioned in his presentation. But one thing that we wanted to add to what he would have said is that the Serious Fraud Office in New Zealand, they confirm investigations when appropriate, and what they consider to be appropriate is if their involvement has already been made public, so the fact that an investigation is being undertaken by their agency has been made public, no fault of their own, or that public cooperation is needed, which is the point that we are really interested in belaboring, because what we would want to create an environment where whistleblowers are able to come forward with pertinent information and be able to provide that information as expeditiously as possible. And we acknowledge that the interpretation of the section so far that we've heard in discussions has said that they can table whatever matter, which wasn't our original interpretation, whatever matter in front of Parliament on a weekly basis, but we also consider whether this is the most expeditious method of doing this, whether or not an investigation can require this information to come out earlier, and whether the tabling of it in Parliament could be a hindrance to evidence, relevant evidence, being gathered in pursuance of the investigation. So we would ask that this section be amended similarly to the Serious Fraud Office provisions in New Zealand, where that discretion is there, so that if it is necessary for public information to continue the investigation, the public announcement can be made. And we also would like to institute the same restrictions that they would have, in that the normal procedure, as Professor Monroe would have also said, is that the investigation is not announced until it is there's time for charges to be laid. So unless it is that it is in the public interest to do so, the announcement would not be made unless charges have been laid. So that is JFJ's position on that.
Yes, and just to add to it, our submission had in fact made reference to the Serious Fraud Office Act within the United Kingdom, I believe. But we are open to looking at the New Zealand model, specifically given Member Chuck's response and reference to that yesterday. But for clarity, what we're asking for is for discretion to be placed within the Integrity Commission Act rather than what is perceived to be a blanket gag order. And we make reference to the presentations from the Integrity Commission itself and the fact that since its inception in its annual report, it has been calling for this to be repealed. But we just want to be very clear that discretion and procedural guidelines are what we're asking for. I'm looking at your expression, Member Malahoo. Go ahead, please.
Through you, Chairman, may I just be permitted? Don't try to read the expressions, Ms. Jackson, through you. I just want to understand the argument, because that's really what I'm seeking to understand. JFJ's argument is that the tabling of a report may hinder the gathering of evidence. Is that part of your argument? And so it is not viewed as an expeditious way of enabling the Commission to carry out its work. Is that a fair?
Well, that is part of our argument, yes.
So walk with me a little, since I know the gist. I've seen the summary of the recommendations of the submission. So if you were listening on the periphery to the previous submission, the report that is to be submitted is under Section 36, Clause 53.3 references a report under 36. And 36 speaks to the annual report that is to be tabled. It speaks to Parliament requiring an investigation, and then a report is to be tabled on it, or the Commission submitting a report in any matter which, in the opinion, requires special attention of Parliament.
And sorry, not to cut you, Minister, but I want to be very clear that the content within such report, if we look at the second schedule, I believe, and you can correct me, I'm not looking at this specific provisions.
That's the annual report. That's not the special report of investigation.
Okay, so my question then becomes, the special report, is there guidance on what that content should look like?
Well, you ask for latitude to be given to the Integrity Commission, and that is what 3 does. It says a particular matter which, in the opinion of the Commission, requires a special attention of Parliament. But walk with me now. If it is that it is the notification of the Parliament that may operate as a suppressor of the information, why do you think that the public announcement in the public square would not achieve the same goal? Meaning that when the Integrity Commission convenes its high-level press conference and it goes out, you think that any parliamentarian wouldn't be listening attentively to it? And do you think that if there is any surreptitious move that couldn't be done there? What I'm trying to get at is that when you read how the law empowers the Integrity Commission and the functions and the objects, I'm still trying to understand why is the picture being painted that unless we emerge from this deliberation and review, doing away with the restriction on disclosure, then all of us would be complicit in corruption and would somehow be conspiring to disable the Integrity Commission from doing its work. I really want you to help me to understand it, because
but a point
like
of clarification, though, from JFJ's standpoint, I wouldn't want the Joint Select Committee to ever think that that is our perception or what we would want to be promulgated in the public space. Because to be very clear, some of what we saw happening perhaps in the past, we do not stand for it because reputation is important. We just want to be very clear. What we do not stand for, which is why we're asking for a discretionary clause to come in and guidelines. Because, Member Malahu, if it is in your belief, your reading of the law, you see that side or that context of latitude, but the Integrity Commission does not share it, then what we're seeing is, why not make that point of clarification very clear? I think that is important.
Miss Jackson,
yes.
When the law says that the Commission may at any time, submit a report relating to any particular matter which, in the opinion of the Commission, requires the special attention of Parliament, tell me, does that give them great latitude to opine in their wisdom on what could require the attention of the Parliament? When the law says that the Commission may, at any time, be required by either House of Parliament to investigate a matter relating to an act of corruption and table a report. And when it says that the Commission shall, not later than 3 months after the end of each financial year or within such longer period as Parliament may approve, submit to Parliament an annual report relating generally to the execution of functions of the Commission during the preceding financial year, and then it prescribes what is to go into it. And then it says a report submitted to Parliament shall exclude matters that may, if included, prejudice proceedings in relation to any matter referred therein, and shall not contain any communication which is subject to legal professional privilege. So no issue, the only issue that was taken with 36 was by one of the presenters as to whether the special attention of Parliament. But Parliament may have interest in just about everything in the nation, but not everything may require its special attention. And that is why the discretion is given for the Commission to opine, given its functions and its powers, that this is a matter, public bodies, acts of corruption, public officials, that the Parliament should. And then all the clauses saying that until you do that, do not do other things. But it also goes on to say that nothing in that clause which restricts your advising of the matters shall preclude the taking of any administrative action. So you can summon witnesses, right? Or the initiation and conduct of any proceedings. Remember, already you can't include prejudicial matters because you're forbidden from doing so under 4, properly so. You can't include communication which is subject to legal professional privilege, a standard sacrosanct principle. So I'm just trying to make the link because it does appear that the clause is being read in isolation without sufficient regard to the extensive powers that are given in the Act. And as you've rightly identified, a model that is uncommon. As a matter of fact, the issue of the prosecutorial power does pose some constitutional issues. But the Parliament nonetheless went ahead and provided for a special anti-corruption prosecutor. We had to reconcile it with Section 94 of the Constitution because we can't pay lip service to rule of law unless and until a law is changed. The law is what it is, and the Constitution, especially the entrenched provisions. So I'm just trying to understand, because the argument that the notification to Parliament is going to act as, the word escapes me, but it's
impediment,
signals.
perhaps? Okay, I was suggesting impediment based on where you were going.
It's a tip-off. Tip-off is the word I'm looking for. But why you think the announcement and the press conference won't do the same thing? I'm just saying, let's examine the argument, because the goal is to ensure in a small society like this, where people are complicit in the acts of corruption, people may themselves have motive to make allegations, and we don't have a history, as you rightly say, of many matters ending in prosecution, because we can't compromise the standard of proof beyond reasonable doubt for a criminal conviction.
Which perhaps, Minister, is the very reason for us saying that we need the Commission to be able to speak appropriately so, because I think I've made it very clear on JFJ's behalf that we're not asking for a blanket, let the Commission speak however it wants to. And I think we have made it very clear that we agree with the previous presenter that it will not be left up to a single individual, as it perhaps debatably so in the past, but more so to a collegial approach. And we believe that though you can pursue administrative proceedings, summoning of witnesses and so on, perhaps it is the announcement of that that would allow you to secure such witnesses. My colleague spoke earlier about whether or not limiting that possibility only within the context of Parliament may prevent us from acting expeditiously. And that is something we're asking Parliament respectfully to consider, that we must be looking at how exactly are we able to get persons who are potential witnesses to speak, to participate in something with appropriate procedural guidelines being tabled within the Integrity Commission. Because what I wouldn't want either, Minister, is for persons to perhaps take the comments, your reading of it, and then some of the concerns that we have had in the past may very well be returned to. So I think it has to be a balance with what you have also indicated.
Sometimes, you know, Ms. Jackson, when people dominate a space and intimidate others and prevent them from speaking up, threaten them, kill their families, those people need to be separated from the space for a while. Perhaps that is also part and parcel of the consideration. In a culture where people talk and announcements are made and little follow through and there are big exceptions, isn't it a time for us to just really rethink the cultural things in Jamaica, that, you know, this talk everything down to a point that is not followed up with substance? Don't you see that some of it is being replicated in the very ask that we're saying when it comes to matters of prosecution? These are not matters to be taken lightly. But and yes, it is true that people, generally, we have a culture of intimidation. And interestingly, the JFJ does not seem to always make that link on other side of the law. When we say that the interest of justice demands that certain people be separated from a space to allow others who are being intimidated and threatened left, right, and center to be given room to breathe and to be given time to build up their courage to speak up. You hear all kind of thing. So we're talking about striking the right balance. The law does not prevent the Commission from speaking. Why is there such umbrage being taken to saying report it to Parliament? Why can't the Commission not simply say to the Parliament that we are investigating this matter and thereafter these are the allegations that we have received, or we have acted on a report, whatever it is, the source, without disclosing it and prejudicing any source, and thereafter, the very day it tables the report, call its press conference. If it fears that the tabling of the report will not lead to a debating of the report on the floor of Parliament and then achieve the very goal, why doesn't it do it at the very early stage? Then, if you're talking about expedience and time lag, it just begs the question.
I asked the Parliament and the committee to consider if there is no situation in which the tabling of Parliament would be the hindrance that prevents the evidence from being collected because of the time that it would take for the report to be prepared to be tabled in Parliament.
You know, I perhaps, Chairman, through you, we may need to bring back the Integrity Commission. through
we
you.
are running a little
Yeah,
close on time.
to find out a little more about the practices of the commission on that. But again, you know, I want you to think full circle about the work of JFJ, because you focus so much attention on the harm that is done to an individual during the due process phase.
Yes,
and
there's
the
always the presumption of
criticality
innocence.
that.
Yes, there's
Absolutely.
also the presumption
no,
of innocence.
just link it to the core function of your work, where you began, and the things that you normally focus public attention on. And just see whether writing, proper documented material wouldn't be a critical part of the investigative process leading to prosecution and hopefully conviction in an appropriate case.
We're not saying it's not. We are asking the Parliament to consider that there may be situations where the Commission, for the best functioning and for the best conduct of the investigation, need to make a statement to secure the necessary evidence before they would be able to table a report in Parliament. That's all we're asking for the Commission to consider. And in that consideration, we would need to amend the section so that we are able to have those considerations made when the Commission is carrying out its function.
Noted.
Thank you very much. Now,
yes.
I'm going to, before we ask Member Hamilton to make her contribution to this discussion, I'm going to ask Member Warmington to assume the chair for the remainder of the meeting. I apologize, I have to go out for a very important 12:30. But just to remind you that we have to vacate here at 1 o'clock, and also that the committee will meet again on the 22nd of November. No.
While you deliberate, just to say, look at, as I said before, look at 6 thoroughly, and you may see that that which you're seeking may already be provided for. I don't understand why the Commission has interpreted the law and is restricting itself the way that it is restricting itself in the presence of clear provision, wide provision, and giving the impression that unless we somehow agree to lift the restriction, as a juncture, then we are all complicit in corruption. Most unfortunate.
I think it's 2 things that the Joint Select Committee can also consider, and one of which it sends a signal, intended or not, and I think it is an unintended signal, that there are 2 different applications around the matter of reputational damage. Because if every other agency, to the best of our knowledge, allows for public statements to be made that may very well have implication for persons' reputation, what would be different for public officials? That may send an unintended signal to the public that the application of law is not equal. And that is something I think the Joint Select Committee must consider. The other thing for the Joint Select Committee to consider is that reputational damage is not only to individuals or agencies who may be the subject of investigation, but certainly to the Integrity Commission itself. So I want to be very clear here. JFJ's position on this particular matter is trying to strike the balance between the potential reputational damage to individuals, to agencies, but also trying not to undermine the Integrity Commission. I heard Professor Monroe spoke to the matter that has been in the public space recently. We all know about it. And my personal comment to the issue is it can undermine the public's trust in one office and undermine it in another, if it is that even statements of clarification can't be made. So we may be trying to fix something but cause further harm in the long run to the Integrity Commission itself and its mandate to ensure that corruption is eradicated. And that is something that we're asking the Commission to consider. And I did say in my open statement that silence in and of itself can breed a further undermining of trust in the public institutions that are expected to do their work. And I think that is a point that the Joint Select Committee, I urge you to consider the implications of that, because when you look at our other segments in our report, you mentioned, Minister, for example, potential of witness protection and so on. Jade is going to be talking about that. You mentioned processes to guide the Integrity Commission. And if you look at the point that we have here, and I will allow Jade to speak of it, because we're asking perhaps for Section 20 of the Office of the Contractor General provisions. It's not stated that way in our submission, to be considered for review to place back within the Integrity Commission Act. So I'm going to ask Jade to speak.
Just before, through you, Chairman, so let me make it clear that my concern for reputation, parliamentarians, that's the least of my concern, because in the conduct of campaigns, all kinds of accusations are levied.
Yes.
And on the floor of the Parliament, all things can be said that are not subject to defamation claims. So that my concern, just in case anyone listening may misconstrue, it's not the reputation of parliamentarians. This is a ground where practically everyone alleges that everybody is corrupt, etc., etc. But we have other public officials or judiciary, right? We have important public officials that we need to consider. And somehow I believe the consideration seems to be intentionally or unintentionally focused on the parliamentarian. Parliamentarians are a small subset of the subject matter of the Integrity Commission Act. Small subset. And for all of us here, let me tell you, in the democracy of free speech, it is not for us that we are primarily concerned. Taking your point about not just personal, but institutional harm.
Thank you, Chair. Just for clarification, I think it was mentioned earlier that there is no power of the investigative officer to search and inspect.
We're asking for it to be broadly stated as it is, and we made reference to Turk and Caicos.
So, at Section 45 of the legislation, specifically 45(1)(b, it makes reference to powers, authority, and privileges given under Part VIC of the Revenue Administration Act. And when you go to that act, at specifically 17J and I, it speaks to power to inspect, audit, and examine books, accounts, records, property, goods. And it also speaks to the power of search and seizure through obtaining a search warrant from a judge. I think that's broad, very broad powers. There was also the request for the gag order to be removed to allow for these things, or to what was the term used? To facilitate. But I would imagine
I didn't hear that, member. My apologies.
The gag, you made mention of the gag order.
Just a minute, it's going too often. When a member of this committee is speaking, nobody interrupts. If you have a comment to make, you allow the member to complete. One thing we don't do here, we don't allow people to cross-talk the members in this any committee that I'm chairing, or I'm a part of.
There was mention made of the removal of the gag order to facilitate in, search and seizures and inspections. There was mention made of that earlier, but I would think that any investigation being done, that element of surprise is necessary for any investigation. I don't see why it's required for disclosures to be made that you are doing an investigation where you would want to go and inspect and search and seize property. But additionally, if it is that you require the removal of the gag order, would your entity also propose or accept the defamation privilege that is afforded to the Commission? Would you accept that that should also be removed? And any other privilege that they now enjoy?
Just as a point of clarification, I think a recommendation that we made perhaps was seemingly conflated with the gag order. It's two different things. We were asking, one, for the investigative powers to be broadened to assume that of a constable and a justice of the peace, and you made reference to Section 45, which we will revisit to see if it does in fact consider the recommendation that we have highlighted. I will allow Jade to clarify the point around the gag order, and then I will answer the question that you raised around the defamation issue. And I think Minister Chuck had in fact raised that as well yesterday.
Yes, the point that we raised around the gag order was not in relation to the conduct of investigation for search and siege and in looking at documents and that kind of thing. It was about allowing for witnesses with evidence to come forward in an expeditious manner. It was not about the ability to search documents.
But if I may, if you look at Section 37 as it relates to complaints, it does not preclude anyone from any time, whether it is evidence you're going to give as a consequence of a notice that an investigation is going on. Anyone may, at any time, any person, and I will read, may orally or in writing make a complaint, give information on or notify the Commission about a matter which involves or may involve an act of corruption or non-compliance with the provisions of this Act. It doesn't necessarily mean that, okay, because you hear that John Brown is being investigated, you have information. You can write a letter, you can call, you can be anonymous in terms of what you do about a particular view that you have about corruption involving a particular person, and the Commission will investigate.
Yes, and while we acknowledge that, we have to also acknowledge that persons may have information and may not feel confident in bringing that information forward, not knowing whether or not that information will be used. And it's more likely, as we would have seen in police investigation and the investigations of other agencies that have similar powers, where the investigations are announced to facilitate persons coming forward. We have seen it work, and we know why it's done. So I don't think that it is similar for making a regular criminal investigation. If it is that a person knows of a crime, they can report it. But if it is that a person is told that an investigation is taking place, they are more likely to bring evidence forward. So that is our position on that.
Member Holness?
Just a question for you, and I'm really sorry I didn't pose this question to the Integrity Commission.
Just a minute. She hasn't completed your supposed response. Just a minute.
Oh, the question about the defamation? I would submit that that is something for consideration of the Joint Select Committee.
Yes. Member Holness?
My question to you is, over the last year, 5 years, 10 years, are you seized of any information that gives any indication as to the level of corruption investigations, criminal investigations being undertaken by the Integrity Commission? And I have asked this question primarily because what I know to be a lot of the investigations is usually asking for more documentary proof, and I am concerned, as happens in Jamaica, once it is argued someone is being investigated, once it is argued that an investigation is underway, usually it is not an issue of corruption, but that is the perception of the public up front.
Yes. To respond to your question, Member Holness, I will say this. One of the concerns that we do have is that the inability to clarify is what may cause further distrust within the public, and certainly from our lens. I make reference to the recent FLA report, and we also had our own concerns about it, because there were some recommendations within that report, and all it did, which we were concerned about, that given the powers of the Integrity Commission, it made reference to, referred to FID, referred to MOCA, and it begged the question, why couldn't the Integrity Commission act more? And nothing was put forward. So some of the concerns that the Joint Select Committee has expressed, we also share it, not only as an agency at JFJ, but also as citizens of Jamaica. And it was that in mind that we're asking, we can't have an Integrity Commission saying, I can't comment because the law prevents me from doing it. And that is the concern that we're having, that the gag clause, though the intent of the Joint Select Committee and Parliament is to safeguard reputation, if it is that it's just documents being missing, the fact that you can't speak our argument in part is that it may further serve to undermine public confidence. And I think that is something, again, for the Joint Select Committee to really consider. I hope I answered your question.
Well, I do note that you have not been able to give any indication as to the number of criminal investigations that have happened in many, many years. And I am very critical about asking that question for the public's interest, because I do also get a sense that the perception of Jamaicans being corrupt comes from the level of discussions we have surrounding persons being corrupt, not necessarily proven to be so.
Yes.
Member Malou-Fort.
Thank you, Chairman. The more I think about this matter and the arguments you have presented, is the more I am convinced that setting out something in writing, so it seems to me that umbrage is being taken to reporting to the Parliament before, that the Integrity Commission takes offense to a requirement that they must table a report before they speak to matters under investigation. But we're investigating with a view to prosecuting, with a view to convicting, with a view to holding account in the most consequential way. Hearsay can't go law, you know. Hearsay can't go law. You know, writing something down provides an opportunity to clarify, provides an opportunity to address issues of cogency. And once you take into account what has to be excluded by virtue of Section 36(4), that is, any matter that communication which is subject to legal professional privilege, or if prejudicial. The same kind of thing that a court would have the power to exclude. Because if the prejudicial effect outweighs the probative value, an application can be made successfully to exclude those matters. So when you think about the discipline that the provision is seeking to cultivate or assisting to cultivate, because there are many ways we can look at it, many ways. And it seems that it's been looked at in a way that is going to paint the worst light on parliamentarians who are democratically elected to pass laws for peace, order, and good government. But I remind that the law is not just about the parliamentarian. It's not just about the parliamentarian. And the issues of reputation, the parliamentarian already lose that, because when they get up to cross-debate, nothing they say is subject to defamation suits. So why is the Integrity Commission taking such offense to a requirement for them to make a report to the Parliament and then speak, when it is given such wide powers in Section 6 to achieve its functions and objective? It really begs the question. I think just about every presenter in the cross talk speaks to the absence of trust and confidence and the need to build trust and confidence. You know, the lack of trust and confidence is not, the Parliament has no monopoly on that. And really, this is a Jamaica that we're seeking to build out. Maybe it's a time to examine all our motives. because the Parliament passed a law that went above and beyond the model, taking into account peculiarities in the Jamaican society. The Parliament then approved a budget to enable the IC to be fit for purpose. And in all of this, we're still hearing that it cannot do its work. Talk to the people, man. Go talk and reason out. These are the kind of things that lead to corruption, because there's a level of complicity in the society. You know, you ask me to break the law, and I break the law for you. I'm the best thing. You get through. But I break it for somebody else, then the other person and me corrupt. That's part of the culture in Jamaica. You know, everybody want a bly. Everybody want a string to pull to get through. And once they are the beneficiary, everything good, everything crisp. But if it's somebody else, it's all about corruption. So there is a lot that needs to be probed beneath the surface about the culture of Jamaica that this law has empowered the Integrity Commission to do. And everyone who's interested in the fight against corruption to enable us to achieve our development goals better. The restriction until the tabling, believe me, that on my reading of the law shouldn't disable the commission, shouldn't put it in coma, and it certainly doesn't. So why is the commission giving the public the impression that unless and until we the parliamentarians agree, something wrong with us? That bothers me, because I'm still waiting to be persuaded. And the arguments do not persuade me when 56 is read in conjunction with 36 and 6 and 5 and all of the other provisions.
And if I may add, members, one of the beauty about a Commission of Parliament is that there is the Oversight Committee. And what I'm sensing as well is that there is seemingly some concerns about the efficacy and effectiveness of the Commission in some of its duties around public education. And if I may, that seems to be an operational issue outside of the legislative framework that perhaps would need to be addressed by the Oversight Committee.
You see that?
In its duties. Well, that's what I surmised from you as well. So,
Chairman.
I acknowledge that, if you will, through the chair, and I think the point I'm making is it's two different issues that I think we would need to reconcile.
May I just support my colleague, Minister Ford? It is very important, and I totally agree with openness and transparency, but there has to be a proper process. Only yesterday I said to the Integrity Commission, put in a toll-free line, 888 corrupt. You know, like how we are promoting justice now, 888 justice. Any information about justice, 888 justice, you can get information. We want, wherever any citizen of Jamaica, or integrity, whatever. The point I'm making is that we want every citizen of Jamaica, wherever he or she sees corruption, to expose it. Call the Integrity Commission, inform them. I have no doubt to see far too many people, rather than highlighting incidents of corruption, is nothing but speculation. And that is why the perception of corruption in this country is way out of line with actual corruption. I have no doubt that there's corruption, but they need to be exposed, because when you broad brush, all politicians are corrupt. You know, as far as I'm concerned, don't bother me, because I know my position, fine? But we need for the Integrity Commission to use the Protective Disclosure Act, invite persons, Jamaicans of Justice can assist, NIA, whichever, to promote that we want a strong governance without corruption. But we don't like this idea of speculating and investigating, and then at the end of the day, you are damaged. I see too many cases where allegations have no foundation. And if you just say we are investigating, it gives substance to those allegations. That's a concern.
I just want to put something on the record to underscore the point that in case anyone thinks that we, the parliamentarians gathered here to review the bill, are more concerned with our reputation. Just be reminded, we're a small subset of the subject matter of the law. But the Constitution itself, at Section 48, subsection 3, provides that no civil, no criminal proceeding may be instituted against any member of either House for words spoken before or written in a report to the House of which he is a member, or to a committee thereof, or to any joint committee of both Houses, or by reason of any matter or thing brought by him therein by petition, bill, resolution, motion, or otherwise. I say that to say we are least concerned about our reputation, because on the floor of Parliament, in a competitive political space, any kind of allegation can be levied. And right now, the public have the opportunity to tune into Parliament, because all proceedings of the Parliament and committees of the Parliament are broadcast live. So anyone think that in our assessment of the clause, it is because somehow we have something to hide or we have a special need to protect our reputation, far be it. We have a duty to ensure that the laws that we pass allow this country good governance, peace and order. And we have to look at all our institutions and all of our office holders, every single one of them, and strike the right balance.
Let me try this now. So I am. When I don't like the narrative which is being projected to the public, that the Integrity Commission and the Parliament are in an adversarial situation. I would like that to be corrected. And certainly I think if the Integrity Commission was more mindful of its duty to educate the public, we would not have to express that kind of concern. Just yesterday, I had to make it clear to some people that there are over probably close to 50,000 persons who make statutory declarations which have to be examined. But the focus is only on parliamentarians. We know that there's a level of mistrust from the public towards politicians. I deeply regret it because I happen to sit in one of those chairs. But I don't want to see it constantly perpetuated. And that, unfortunately to me, is part of what is happening in this dialogue. I want to assure the public that we are trying to be fair and balanced in how we are approaching these deliberations. And even the things that we say now to you and to others, it does not mean that when we go into committee, we might not come up with a different sort of assessment. That is what I really want to communicate. Finally, I would say that we cannot disabuse our own minds of what has happened in the past. We cannot disabuse our own minds. We have a duty to take it into account and to look at it and consider whether we have, in fact, put safeguards which ensures that it will not happen again. So I thank you for your submission. I speak to the chair now to get some guidance, as it is 12:50, and there are matters which have not been addressed yet by Jamaicans for Justice. So I want to know how we shall proceed. I wanted to ask them one question on one of the matters that they raised.
Yes, you want to ask a question, sir?
I have no, but they haven't addressed it yet. I don't know how much they have left in terms of what they have to say. And that is why, Chair, I am looking to you.
No, we had quite a few more points to go, but we will make reference to our written submission. So we would have addressed some of the concerns about reputation with our point about notice of adverse findings. And I'd just like to say to opine that it is not JFJ's intention to perpetuate any negative perception between the relationship of the Integrity Commission and Parliament. It is only our intention to ensure the best effective operation of the Commission in carrying out its investigations as we would have seen in other investigative bodies. Yeah, I understand, but I would just like to clarify on our behalf. I'd also like to point the Commission to our section on strengthening the anti-corruption legislative framework. We make reference to the provisions that are addressing bribery in the UK and how those provisions can be implemented in our Integrity Commission Act to strengthen it. We also make reference to, and this is a point we hoped we would have gotten to fully ventilate, but we hope that if any questions come, parliamentarians would send those to us, but we would want to talk about how we can strengthen citizen participation. So we have 3 points in that. One of them, Minister Chuck would have referenced. This is a similar point to ours, which is that we would want a mechanism for anonymous reporting. Capri would have mentioned that in a research that they did recently, and they suggested the citizen feedback monitoring program as a mechanism, but we can also see where Minister Chuck's suggestion may also work. We also made reference to the extension of protections for those persons who are witnesses. And what we acknowledged was that when persons are whistleblowers, if they do not arise to the level of a witness where they would be given evidence in court or expected to be giving evidence in court, they do not have the same level of protection. And therefore, when their reports are made, they may be putting themselves in harm's way. And in the Integrity Commission Act, the only safeguard for them is that of financial safeguard. So we think that that should be extended, whether that would be through the Justice Protection Act that already exists or that would be through the Integrity Commission Act itself.
Yes. Thank you.
I'm sorry, just one last point, and that would have been related to remedies available to those victims of corruption, because we acknowledge that persons who are victims of corruption are not just entities and companies, but also individuals, and to see how best the Act can be strengthened to improve those redress mechanisms for those persons. So we ask that you look at the points fully ventilated in our submission as we're out of time, and we thank you for allowing us to make our presentation today.
I'll thank on behalf of the members, the JFJ, for their presentation today. And we take note of your submission.
Yes.
And we'll certainly take them into consideration when we reach the stage of our final report. So thank you very much.
Thank you so much through you, Chair, and the members. We are grateful.
All right.
Chair. One other point, Chairman. Jamaica, in your presentation, you had a number of points in relation to the Protective Disclosure Act, okay?
Yes.
No, it's a separate committee.
We do have we made a separate submission around the Protected Disclosure Act,
okay.
But the point that we were making, which Jade alluded to,
right,
was that as you talk about the powers of the Integrity Commission to summon witnesses and so on,
right,
therefore it has to go beyond the monetary pieces.
No, I just wanted to say that within the next few weeks, we will have not the same, it's almost the same committee, 1 or 2 changes, so you can return to make the presentation and protective disclosure. It's a different committee, so I just wanted to indicate that to you. Okay.
Thank you.
All right, let me clarify here. The Joint Select Committee that will meet on November 22nd, that's to deal with the Protective Disclosure Act. And the members are almost similar. So that's what we'll be doing then. So thank you very much. Most of us will be back here on the 22nd. The meeting stands adjourned so the Parliament can get prepared.
Chair, we have a housekeeping matter, Chair. Mm-hmm. A housekeeping matter in relation to another entity that would like to present.
Oh, yes, go ahead.
I'm not sure if the committee would be minded to hear one final presentation made from an entity. Well, I think the submission probably has already been made to the Parliament. I'm not sure under what grouping it is.
Which one?
I'm not sure under what grouping the submission has been made, so I don't want to state, and I may be incorrect. But there's another group or individual that would like to make a presentation before us.
The secretaries are aware.
So if it's submitted, then it will be circulated, and then we can take a decision then.
Okay, noted, Chair.
All right, thank you very much. The meeting is adjourned.
Something is happening for someone in this country every single day as a result of the actions of this government. The beneficiary of this house and the hundreds of people who have benefited so far, they feel good and their families feel good.
Oh, I'm on top of the world. It's just a dream come true. Somebody see that me deserve it and then brought it to life for me.
There was no schism, there was nothing there, and it was just, okay, you're in need, and I'm going to do whatever I can do to ensure that you're helped because you're somebody that is in help. It renewed